People of the State of New York versus Arthur Ellis. Thank you. Counsel?
May it please the Court, Catherine Morrill, Assistant District Attorney, on behalf of the appellant, Essex County District Attorney, the Honorable Christy Sprague. At this point, I'd like to request 2 minutes for rebuttal.
2 minutes?
Yes, ma'am.
You may.
Thank you.
Counsel, the defendant requested in this case, I believe, a bill of particulars, but I don't think that there was one that was served. So talk us through Internet Identifier.
Yes, ma'am. It's appellant's position that in the legislative enacting the Electronic Security and Targeting of Online Predators Act, ESTOP, that the intent was made clear that social networking and social networking websites and the use of those in the hands of sexual predators create and present a clear and present danger.
What would you have this defendant disclose that he didn't disclose?
Yes, Your Honor. Well, and I think that brings it to the legislative intent. So if the court looks at Corrections Law, Section 168.
But before we get to that, like, what information do you think should have been on his disclosure form that wasn't there?
Sir, under Section 16, Facebook. Disclose your Facebook account. Disclose your Skype
what does
account.
that mean, though, in terms of practically what should this defendant have put on that line?
So on that line, Facebook account, which is under 16, the authorized internet entity, which the third department held Facebook is, and which appellant agrees with, but also under Section 18, the internet identifier.
Internet identifier. So as I understand that, that's an email or a screen name, and looking at his disclosure forms, seems like those were disclosed. So I wonder what else could he have disclosed?
Specifically his designation, so not his email address, but
so
his
when you
designation.
say his designation, I'm a little unclear. What do you mean? He disclosed his name, and on his Facebook account he uses Arthur Ellis Jr. ESTOP is to identify those who use some abbreviation or some pseudonym, and to allow the authorized internet agent or account to police their account, to identify those people that are sex offenders. Here, he gave his name. There's no better information that he could have given than his name.
And the email he used to open the Facebook account. So I thought the idea of the statute was that can then be harvested by the Facebook or other providers to identify accounts, and then they have the option of removing those accounts from the site. So what else does he need to disclose?
He needs to disclose, as required by the legislature, sir. The intent is who you're representing yourself to be on that social network.
But he did that. He said Arthur Ellis Jr. Aren't you really saying that he needs to disclose not the internet identifiers, but his Facebook account himself?
Respectfully, both, sir. And if the
Okay,
court
so let's stay with the second one, that he needs to disclose his Facebook account. Is that required?
Yes, under the statute it is, Your Honor.
And then why doesn't he have to disclose his Amazon account?
Because under subsection 18, if he were using that Amazon account for the purposes of communication or any other internet entity as defined in subdivision 16, he would be required to disclose
What
that.
about an account like WhatsApp or Snapchat that are both under, I'm told by my child that they're both under under your telephone account and not under your a direct internet account. So you would simply text on those. There's no requirement that you disclose those.
I think, sir, that the intent of the legislature in enacting this is to encompass all of those entities that are defined in 16 where the user is interacting.
Okay,
And
but let's go back for one moment. When you say account, what do you mean? That he was supposed to write on this form Facebook?
Yes,
I
ma'am.
think that's what Judge Garcia was trying to get to in the very
Yes.
first question.
And so,
And then Twitter or WhatsApp or any of these, which you seem to say he's got to reveal everything?
yes, because if the court looks at subdivision 16 and 18, it's the people's position that you can't parse them out. And so in interpreting a statute or statutory interpretation, the fact that the third department looked at section 16 and without considering section 18 together renders the statutory intent meaningless. Because under
I thought the
section,
intent was not, it seems like if you had that requirement, the intent would be, okay, I list Facebook, and then someone's going to go to Facebook and say, hey, by the way, can we see this? Or I thought the intent of the statute was to provide access by Facebook or whatever the provider, to say, once they get this information, they can do their own check. And then they can take whatever action they deem appropriate, including delisting or taking the site down. So that was the identifier, because that's what Facebook is going to use to find the accounts. It's going to be the name, the email, the screen name, and that's what was disclosed here. So I don't see what, again, going back to my original question, what wasn't disclosed that would be required to effectuate the purpose of the disclosure statute? Because putting Facebook down there, if you put nothing else, isn't really going to do anything.
exactly, just putting down, I have a Facebook account, I have a Skype account.
But putting
I
the
have-
other thing without putting Facebook gives them enough information to do what the statute intends. So I have a hard time seeing how you could charge this defendant with not putting down information that isn't necessary for the purposes of the statute and isn't listed.
And so the people note that the appellate division found that looking at the DCJS form, there was no specific requirement that you have to list out a Facebook account. And they looked at it in an exclusionary fashion, but it's appellant's position that that language in that form is inclusionary, and it's supposed to be broad encompassing as the statute is.
The terms identifier and the internet access provider, that's all defined.
Yes, ma'am.
And do you agree that what you're suggesting, Facebook, for example, doesn't fall within an authorized internet entity?
We agree with the appellate division that yes, it is in fact an authorized internet entity, but the fact that somebody has a Facebook account
Sorry,
without
you're right.
providing who they are, who they're representing themselves to be, is of no meaning to the statute.
But the form doesn't ask the offender to indicate the authorized internet entity. And it seems to me, maybe, I assume that you've looked at the statutes of other states, you've looked at how SORNA addresses this, that they're very clear when they want to require an internet identifier and the corresponding websites or internet entities. And there's nothing on the form that would make that clear. So it seems to me if it was so important, either the legislature or the creator of the form would make that explicit, and that an offender who's registering wouldn't have to guess at that.
Respectfully, the legislature, in enacting this law, specifically stated that the existing law couldn't keep up with the ever-evolving nature of the internet. And so to the effect that the form would require, please list your Facebook account, please list your Skype account.
No. Just say that you have to list all accounts in which you are engaging in this social networking on the internet. It doesn't have to list the specific names, but on the form itself, it clearly says service provider, right? And he lists Time Warner Cable and Roadrunner. That's accurate as far as we know, right?
Correct.
And then it says screen name, and he lists 2 screen names under that. And then it says email address, and he lists that.
But he
where
also,
does it ask for an account on which you're using the internet?
the inclusion of the word including before screen names, email accounts, and internet service providers is inclusive, and it's not exclusive, which brings me to my next point that I see that my time is up.
Isn't, if the judge will allow me, at its core, isn't your argument that a Facebook account is equated with an internet identifier? You're saying they're the same thing.
No, sir. I'm saying that we can't read subdivision 16 without 18. So the fact that somebody may have an account is of no meaning to law enforcement and is of no meaning to these authorized internet entities if we cannot ascertain who somebody is designating themselves to be.
Yeah, but the problem is that the statute says that they've got to register internet accounts with internet access providers. Facebook is not an internet access provider.
We agree with the appellate division, Your Honor, that Facebook falls under the subdivision 16, an authorized internet entity, but that you cannot have 16 without also having 18, which in turn has a requirement that you not only disclose your Facebook account, but who you are representing yourself to be in as many versions of
So more specifically, the language in 168-A sub 18, where it says, and designations used for the purposes of chat, instant messaging, social networking. That's the language that you're relying on.
Yes, sir. And the third department specifically found that Facebook was not a designation, and that is where we
So
respectfully
if you think Facebook is a designation, this is your position?
Yes.
Okay, so then what is his name?
His name would
When
be...
he uses his Facebook account, what would that be?
So under Facebook, Your Honor, you have your account and you use your email address or whatever alias you're using to sign up. And so the Facebook itself is that internet entity by itself. There's no interaction, there's no customer signing up. It is when an individual takes a proactive stance to sign up for services and creates a representation of themselves, whether it's real or whether it's fictitious, and portrays that out into the internet.
And that, you say that's not the name.
It is
I
whatever...
mean, in this case, he used a name. You're saying, but that is not the identifier.
In this case, he did not disclose that he had a month prior opened up a Facebook
No.
account.
I'm asking you, what's his name?
His name would be, Your Honor, whatever he represents himself to be as a result of
But
having
with
that.
vis-a-vis the statute, he's got a Facebook account.
Whatever-
He claims his name is the way, right? He's known on this account.
And
So I'm asking the people, what's your position as to what is his name with respect to the Facebook account vis-a-vis the language of the statute?
His name would be whatever he chooses. If it's his real name, Arthur Ellis Jr., that's who I'm representing myself to be in the world because
Right.
I signed up for this service with my email account. So in that instance, with respect to this defendant, that would be his designation.
Thank you, counsel. Counsel?
May it please the court. My name is Noreen McCarthy, and I represent Arthur Ellis, the respondent. Arthur Ellis, as you know, was not on parole anymore. He had served his time.
Counsel, isn't the intent and the spirit of the statute to be informed, to have the individual reveal their social media presence? And that would encompass Facebook.
It's a good question. I think that the purpose of this statute, and I think we've been going around a little bit on what the purpose is clearly to make sure that the internet is not used in a predatory fashion. I think that the most recent Supreme Court case, the Packingham case that came out, told us to be very careful about this, that we don't want to burden people by saying every time you want to send a message, regardless of what vehicle it is, you have to run down to the police
Counsel,
station and register that.
I thought that the purpose of this part of the statute was fairly straightforward, and it was, instead of the government getting involved in that problematic area, they were going to kick this to the provider. So enough information would be given and disclosed so that the provider could make a decision on whether or not to allow that site or whatever page to continue.
That's absolutely right, and we agree with that 100%, Your Honor.
So my
Facebook-
question comes back to what else could your client have disclosed that would allow Facebook to do that?
Nothing. He disclosed, my understanding of this, and the underlying documents at the trial level were a little bit confusing, but my understanding is that his email address is what he used to access Facebook. He never hid who he was, he never hid any of this information. And the fact that he had a Facebook account, nothing asked him to disclose that. And so you're absolutely right.
So
The purpose was.
This is broader in effect because any provider, any Facebook or Twitter can use this identifying information, putting aside cell phone number for the moment, but can use this to identify an account rather than have the defendant, the person list their sites that they're on.
That's absolutely right. So let's say you use your email address to access Facebook and Twitter and everything else. Maybe you use the same identifier. That's what they want to know, because Facebook knows that Arthur Ellis has an account with them. That's a no-brainer. What they want to do is be able to get into his account and make sure he's not doing anything wrong. And I think the government understood that they couldn't actually regulate that. They couldn't overburden Arthur Ellis about how many disclosures he had to make about the different social networking sites that he accessed. Just how do you access them? And then we're going to turn it over. When Facebook asks us, we will give him, Facebook, your internet identifier so they can go troll through their files, because we don't want to do that. And I think the statutory frame is set up perfectly for that, and they carefully tailored that statutory scheme. I don't think this court needs to demolish that statutory scheme. I think it works.
Can I back you up a second and look at the language of the indictment itself?
Yeah.
Let's just address that for a second. The language of the indictment simply parrots the statute,
Well,
except for Facebook Internet Identifier account, right?
yes.
All right. So certainly parroting of the statute does not make it jurisdictionally defective.
Well, it depends on what you're asking, and that was always.
Well, but as a general legal principle, I don't think you can really argue that. Haven't the people here conceded that the issue really comes down in prior arguments to whether or not the Facebook identifier, Internet identifier account is what he's being charged with? And if such a thing exists, then there may be a violation of law. But if such a thing it doesn't exist, failing to register something that doesn't exist can't be a crime. Isn't that the core of the argument here? There either was a crime that existed or a crime that didn't exist.
Exactly. So the Facebook Internet Identifier account, we never knew quite what that meant.
Right.
If the government said you have to register your Facebook because your and that is what they said, that your Facebook is your Internet Identifier. Well, I think that the definitions just don't support that at all. No definition supports that. If they said that you failed to list your internet identifier, well, then factually they were wrong, because he did. And so
that would mean that the Court of Appeals, really is restricted to the concession that the issue is the Facebook Internet Identifier account.
I don't think there is any such thing. And so I think it was a poorly drafted.
I know that. That's the core of your argument. So there wasn't a crime, right?
So, but I think
that.
what they're asking you to say is that Facebook falls under definition 18 and is an internet identifier, which just simply makes no sense. Why would you have three separate definitions in the statute? And I think that then you run afoul of Packingham.
Yeah, I just read the plea this afternoon before I came down again. And he pleads to both the statute and he pleads that it's a Facebook Internet Identifier account.
I think his attorney astutely had recognized that there was a problem here and tried to preserve his right to appeal that. But as you well know, that.
Well, he clearly did reserve his right to appeal.
Right,
There's no
and
question.
he had no choice as to what language the government was going to put into this, but he did have a choice about how long he was going to sit in jail waiting for his case to be heard. And so I think he did what he could in that situation. But it doesn't cure the problem here, and that he did what he was supposed to do. And there's no question about that, I think.
But on that, typically when you plead, haven't you waived certain things? And I know there's an express effort here to try to preserve it beyond the plea, but I have some concern about that.
Well, I hear what you're saying. The agreement was by both sides, and if you recall during the discussion, the Assistant District Attorney at the time said, we welcome him to appeal that issue because it has not yet been addressed. And so both sides actually wanted the appellate courts to address this issue. But then you leave this man.
But really, I guess what I'm getting at is that, in a way, what you're really challenging is the sufficiency of the evidence at the grand jury proceeding. And that classically is waived once you enter a guilty plea.
I don't think
Am I incorrect about that?
No, I don't think that's what he is challenging, because I think what he's challenging is it's a facially defective indictment. You can, regardless, you can't still have somebody.
So you are saying that your challenge is not to the sufficiency of the grand jury evidence and the fact that that doesn't show that he committed a crime, but to the four corners of the instrument.
I think at this point, we can focus on the four corners. I think certainly.
Aren't you saying that there was not a crime here?
Exactly. There was
Right.
never a crime. And so regardless of whether you
Because
wait.
Judge Feynman's right. If it's about sufficiency, you really can't be here.
Right.
You're only left with the jurisdictional defect.
Right, and I raised that in my brief about the grand jury because it shows what the problem is. I mean, what was presented to that grand jury? And how could they have returned an indictment charging him with a crime when in fact there really was no crime here? So the point is really not whether he waived it or not. The point is, do we have somebody sitting in jail because he didn't commit a crime? And there's a kind of a skewered way of looking at the statutes and a gymnastic way of reading this. And then if you come down to the very end of it, the question would be, regardless of how you interpret the statute, did this man have notice? Because if the appellate court came out with their interpretation and said that the statute doesn't require you to register your Facebook, how would a layperson know that they were supposed to do that?
Well,
And
the
so-
problem that you have there, I think, is no notice is forfeited by the plea, and then you have an unconstitutionally vague argument, but that was not forfeited by the plea, but it was unpreserved. Those are two problems with that one. It doesn't vitiate, though, your jurisdictional defect argument if we take the language that he actually uses. I see.
Thank you, Your Honor.
Thank you, counsel.
Thank you.
Counsel?
Your Honor, the very name of the act that we're here talking about includes the intent, which is targeting of online predators. And we're not just talking about a general citizen. We're talking about a convicted sex offender who forfeits his or her rights by way of having that conviction. So we can't target if we don't have the right information. The mere fact that somebody says, I have a Facebook account, does not help law enforcement, and it doesn't help those social network entities that are interested in protecting their users. So to merely say I have a Facebook account without providing that designation does not further the intent of this statute.
Well, the question is what the designation is if we think that the designation means the email address, the name, whatever, then is your argument, does that fail?
No, Your Honor, because when the court looks in principles of statutory interpretation, subsection 16, subsection 17, and subsection 18, there is a clear delineation between purely email addresses and a designation or an internet identifier with which a person uses to communicate.
I'm not suggesting that it be limited to an email address. It could be any kind of identifier. I just use that as an example. It could be a
Correct.
pseudonym or anything, right?
Correct, but there is a distinction
But
because
that, to me, that's what identifier is. And you're trying to bring that back up into subdivision 16, which I think addresses something different and is not what is requested to be disclosed.
respectfully, the third department found when it looked at internet identifier, you had the part that addressed the email addresses. The third department said, no, that's not a designation. We agree. But then it found when it parsed out the second part of subdivision 18, it found that Facebook is not a designation, and that's where our analysis departs. And I'd just like to briefly discuss in closing, another purpose of this statute is not just to monitor.
So let me just understand designation. So your argument is that When it says designations used for the purposes, you're reading that as Facebook is used for this purpose of social networking, and therefore it is a designation.
Yes, ma'am, a Facebook screen name or however else a person.
Recognizing, of course, that merely saying that is generic and there's nothing particular to any individual when one says that, right?
Exactly, but I think that's why the court needs to consider that in conjunction with subsection 16, which is merely the definitional part of what that authorized
Counsel,
internet.
is there some, I'm sorry, may I, Chief?
Yes.
Is there some other name or identifier, other than just the term Facebook, that you believe this individual hasn't disclosed?
Sir, for purposes of this case, we know that he opened up a Facebook account the month prior and failed to disclose that, so on the
Right, but
facts.
was there anything he used in opening that account, some type of identifier, a name, a nickname, that you believe wasn't disclosed, other than the fact that I went on Facebook and I opened an account?
So in order to open up a Facebook account, you would, one, have to provide your email address. But then, once you sign up for the services that that entity provides under subsection 16, you have to create your name, how you want to represent yourself. So
He did
there's three
disclose
folds.
screen names, right?
But he didn't disclose his Facebook account. And it is not clear, sir, whether that screen name
Again,
is...
I'm sorry I'm being here, but what is that thing? I mean, is it a name? Is it, other than Facebook, is there some other identifier that he was using on the Facebook account that's not disclosed?
So he did provide a screen name.
Right.
But he did not say, I have a Facebook account and I represent myself on Facebook with this particular screen name. So they could be two different screen names, and that's the problem, and that's why disclosure of not
And
only...
where would he have written that on the form?
That would be on the DCGS form, ma'am.
No, where on the form?
I believe, Appellant's Appendix 834.
All right.
Where it requests notifying DCJS of any internet accounts, including screen names. There is a block for a list for a sex offender to provide what social networking entities he or she is using and what screen name he or she is operating under, so that it can effectuate the purpose of this statute, which is to not only monitor sex offenders, but there's also a recidivism component of this statute as well, which hasn't been really addressed in the Third Department's decision or today, but the fact that the internet has this cloak of secrecy and is designed...
Let's assume for the minute he was using one of the, I think he disclosed two screen names here, right, on the form. Let's say he was using one of those as his Facebook name. Would there still be a violation here?
If he fully disclosed, sir, I have one Facebook account or two Facebook accounts, and he was candid with how many names he is operating under, then no, there would not, because he would be complying with the statute.
I guess my
under
question is, if he
168.
disclosed the screen names and not the fact that I'm using that screen name on Facebook, would there be a violation?
There would be, because the legislative purpose of this statute is to also enable those internet entities under subdivision 16 to protect their users. So merely just providing a screen name under 18 doesn't effectuate this purpose, because we don't know what entity is responsible.
But can't the individual entity then go through their records to see if anybody using that screen name is there? Isn't that exactly what was intended by DCJS?
I think what was intended by DCGS was to fill this gray hole between requiring sex offenders to list and be candid
But
about...
my question is wouldn't that accomplish the same thing? Maybe it could have been done a different way, as you suggest, but doesn't that accomplish the same purpose as long as Facebook knows every way that this person identifies themselves and can go search for that, and if that's not there, can be assured, if the person is being truthful, that they're not using inappropriately.
Respectfully, no, it's on the burden of the sex offender, who also has to disclose addresses, where you work, where you go to school. It's just another component of a digital presence that places an obligation on that convicted sex offender.
You don't disagree that the same result could be reached if Facebook were to search its
Tangibly, I think it could, but under the purpose of this statute, that requirement for a sex offender, convicted sex offender, to be candid about that information is exactly what the legislature intended.
Thank you, counsel.
Thank you, ma'am.